Landlords, do you have a tenant that has refused to give up possession of your property, who have refused to pay, and also refused to quit or give up possession of your apartment? Hold on, let me teach you the step-by-step legal ways to recover possession and gain back of your property, instead of taking ways that are not legal and you end up getting legal claims from that stubborn tenant. Step 1, properly go through and read the tenancy agreement you gave to your tenant. If you provided the tenancy agreement before the tenancy, go through that tenancy agreement and see the terms you put in place for eviction. If your tenancy agreement is silent on this, then you have to go by the default statutory means provided by the state which your property is located. This means that if in your own tenancy agreement you give to the tenant, you don't state the way eviction will take place, whether it's going to be a month's notice, 2 months, or whatever you state in that tenancy agreement, then the law already provides a statutory means which you have to follow. That is why we advise landlords, before you give up your property to a tenant, make sure you have a clause in your tenancy agreement which states the mode and the way eviction would take place. The next step is to serve a valid notice to quit. You serve the notice to quit as stated in your tenancy agreement, or if you have none, as stated by the tenancy law of the state which the property is at. Statutorily, for a 1-year tenancy, you are required to serve 6 months notice. That is, if it is not stated in your tenancy agreement. Remember, parties are bound to whatever they agree upon. So you must validly serve your tenant a notice to quit. After the notice to quit has elapsed and the tenant has not vacated your property, then you are to serve the tenant a 7 days owner's intention to recover premises. This is very important for you to serve on the tenant after the notice to quit when he or she does not vacate your apartment. After you have done this, then the next step would be to go to court and file a recovery of premises suit. You go to the court, you file it with all your claims, and then the magistrate or judge, as the case may be, would hear the matter, would see your pleas and grant the necessary application which you filed. Your claims will normally ask for possession, arrears of rent, means profits, and whatever claim that your legal practitioner deems fit. Next step will be obtaining and enforcing the court order. A court order is usually enforced by the sheriff of the court. You don't have to, because you have the court order, now take talks to move out the premises. No, you let the bailiff of the court, as the sheriff of the court, enforce that court order you have. It should be noted that changing locks or removing belongings yourself could expose you to a criminal or civil liability. So please and please do not ever change the locks of the apartment or remove the tenant's belongings without getting a court order or letting the sheriff of the court enforce that court order himself.